So you were in a car accident, but you weren't wearing your seatbelt. Does that mean that you are not entitled to recover for your own injuries and your losses and damages that you suffered? There are 30 states where there is no seatbelt defense in existence. Now, Florida is among 15 of the states that do have a seatbelt defense. Hi, my name is Keith Taylor, and today I want to talk about the effect of wearing or not wearing, rather, your seatbelt if you're involved in a car accident. In Florida, the wearing of a seatbelt is governed by Florida Statute 316.614, and it's called the Florida Safety Belt Law. Basically, there are three types of people who are required to wear seatbelts or safety belts in an automobile. Of course, there are some exclusions like buses and, of course, motorcycles that don't have seatbelts. But in a car, drivers are required to wear a seatbelt. Front seat passengers are required to wear a seatbelt, and anyone in the vehicle who is under the age of 18 years old. All of those people are required by traffic law to wear seatbelts. What if you didn't? Then you are subject to a ticket, a non-moving infraction. The police can give you a ticket for that. But good news is you do still have a claim for your injuries if the accident itself was caused by someone else. Regardless of whether you were wearing your seatbelt or not wearing your seatbelt, you still do have a claim. As I mentioned earlier, it's a seatbelt defense. And as a defense, it is required by the other side, the at-fault party, who has to prove you weren't wearing your seatbelt and that you not wearing your seatbelt contributed to the accident. It's just like if you were speeding. You may still be able to, if you were speeding and someone turned left in front of you, you may still be able to pursue a claim because they turned left in front of you, but you may still be held somewhat responsible because of your speed. That's called a defense, and in Florida, we describe that as comparative negligence. That doesn't mean that you still don't have a claim. You would still have a claim, and if it were tried to a jury would then determine, well, was the other driver at fault, negligent, failing to use reasonable care? And if they were, was your not wearing a seatbelt also a cause of the crash? And if it was, then they have to divide up or apportion the amount of fault between you and the other driver. That's called allocating of fault. Point being, you still are entitled to claim your losses, your injuries, your damages because of a car accident, even if you weren't wearing a seatbelt when the traffic law says you're supposed to be. If you have other questions about car accident cases or any other legal topic, just drop them down in the comments. We're happy to always speak to those and answer them. Also, don't forget to like this video and subscribe to our channel.